Okay, well, let's get this thing started. Um, so tonight we are truly honored to have Professor Steve Wermiel joining us. He is a constitutional law professor from American University. And tonight we're going to talk about the recent Supreme Court term. Steve, did you want to give us a little bit of info about yourself before we get going with some questions about the term?
Sure. I was a newspaper reporter for 20 years before I became a law professor. I covered the Supreme Court for the Wall Street Journal for 12 years. I have been teaching law for a little more than 30 years. I wrote the authorized biography of Supreme Court Justice William Brennan, somebody I hope we all remember well, although he's now been dead for 27 years. And I teach constitutional law. I teach a separate course on the First Amendment. I teach a course on the Supreme Court. I'm very involved in the American Bar Association, civil rights section, and various other ABA things. So that's probably more than you need to know.
Excellent. What a career.
It's
Okay,
been
so
fun.
I guess we'll get things going. The decision, I've gotten a lot of questions and interest in was the Looper v. Raimondo,
Right.
which overturns the Chevron doctrine. So I was wondering if you could start us off with a primer on the Chevron doctrine and what this case means for that.
Well, let me make one kind of overarching comment before I get into that specifically. There were a number of cases this past term where the court could have taken half steps or smaller steps, and almost uniformly, not 100%, but almost uniformly, the court chose to take big leaps instead of small steps. And I think even for veteran court watchers, and I think I've probably earned that moniker at this point, that was surprising. It was surprising that any time the court could do something dramatic and frankly seemingly radical, it did. So with that comment, the Loper Bright versus Raimondo involved what as Nathan described, the Chevron doctrine. Chevron doctrine is from a case involving Chevron and the Natural Resources Defense Council going back 40 years, going back to 1984. In this Chevron case, what the Supreme Court said was when there is an ambiguous law, when Congress has passed a law that has some lack of clarity, has some ambiguity in it, the courts, federal courts, in interpreting a particular situation, should defer to the reasonable interpretation of the agency. The idea was essentially, for better or for worse, we are living in such a complex society, increasingly complex society, that Congress can't legislate every detail and every aspect of an environmental law, a health regulation, an education law, labor law, and frankly, nor do we want Congress to do that, right? Congress doesn't have that expertise. The agencies is where the expertise resides. And so the idea was, as long as the agency's interpretation of an ambiguous law is reasonable, right? It seems like a plausible interpretation, we should defer to the agency. seemed to make perfectly good sense at the time. I suppose little did we know that even at the very moment that that case was being decided, we were in the midst of the Reagan administration, which was planting the seeds of the eventual vast criticism of the administrative state and the regulatory agencies, which basically germinated over the next 40 years, became a battle cry for conservatives. Too much regulatory power, too much delegation of authority by Congress. And so the court could have taken some in between step. The court could have said, we're going to redefine when deference to an agency is appropriate. We're going to redefine how ambiguous the statute should be before we defer to the agency's interpretation. I mean, there are any number of things the court could have done, but it didn't. It said Chevron is overruled, flat out, period, gone, dead. So there is no longer a presumption of deference to the federal agencies when they're interpreting an ambiguous statute. And that's going to be a huge change, I think, in the regulatory state. I don't know how many of you are involved in government regulatory agencies or legal or policy practices where you're dealing with agency rulemaking. But this is just going to be very different. The federal courts are going to have to decide for themselves what Congress meant and not defer to the agencies. The question comes back to something I said earlier. What expertise, I posed it as a question about Congress, but there's the same question about the federal courts. What expertise do the federal courts have to decide whether, X air pollution particulate level is a reasonable interpretation of Congress's statute, particularly when you're asking that question as compared to what expertise would the agency have had for setting that standard. Now, I get there are people out there that think the agency's got too powerful. There may be times when I have some of that view as well, but that called for kind of subtle, polishing and fine tuning, not taking a sledgehammer to the regulatory state, which is what the court did. And if I may, Nathan, let me add in an additional case. The court also decided a case called Securities and Exchange Commission versus Jarkissi, which also dealt a huge blow to the regulatory structure that we have known since the New Deal. What the court said, the Securities and Exchange Commission, like many other regulatory agencies, can enforce its rules, the rules that it makes, in two ways. It can bring an internal proceeding enforcing a rule against somebody, and having that case be decided by an administrative law judge in the agency. Or it can sue in federal court. The agencies have relied heavily on the process of what's called agency adjudication, where you decide the issue through an administrative law judge within the agency. And then the losing party, if you're the one the agency is enforcing against, and you lose in the agency, you can appeal to the Federal Appeals Court. What the Supreme Court said in Jarkissi is no, the idea of having these cases brought in the agency in front of an administrative law judge violates the right to a civil trial in the Seventh Amendment to the Constitution. And so when you combine the demise of the Chevron doctrine and the idea that agencies are now going to have to go to court far more than they did before because of the SEC ruling, we really are talking about the most radical overhaul of the administrative state in 100 years since the Roosevelt began to create all these agencies and as a way to try to get us out of the Depression. So
Wow.
that's the first issue.
Yeah, that's uh that's really just incredible. This has been it seems like what you're saying is that this is an activist court that has a particular view in mind, that they're trying to um, uh, rationalize and use these decisions as a means to their end of attacking the administrative state.
I think that's right. It certainly was an activist court. They didn't have to do this. There was nobody, there's no place written in stone that says we shall review the Chevron doctrine in 40 years and see if it's still workable. It was still workable.
Yeah.
And any problems it had could have been fine-tuned. Can I make one other overarching observation? Some of you may have read, I don't remember exactly when it appeared, but there were a number of people who wrote columns back in November, December, kind of early in the Supreme Court term, maybe January, that Chief Justice Roberts had lost control of his court. Does that ring a bell with anybody? You may remember reading that during this court term. Well, almost every decision we're going to talk about tonight was written by Chief Justice Roberts.
Huh.
So whatever control he lost, he found it again.
So you think that Roberts is leading the court in this direction?
I think Roberts asserted himself to write probably most of the important, not all, but most of the important decisions of the term, and really put his stamp on the court. The idea that he had lost control of the court was a theory that the more conservative justices, Alito and Thomas and Gorsuch, had sort of taken over. They were driving the engine, and that Roberts was kind of running to catch up and see what kinds of middle grounds he could find. Well, that really wasn't the case this term.
Interesting. So just a couple of questions I had on the administrative state and the overturning of the Chevron doctrine, and you touched on a lot of this already. What impact does this have on existing regulations that federal agencies enforce, and what impact will it have on legislation going forward?
The first one is the answer, I think, is chaos.
Mhm.
I think this is good for business. I think it will have corporate interests and business interests more aggressively challenging agency regulations because they won't have to deal with deference to the agencies under Chevron, so they'll feel that they have a better chance of overturning regulations. And they also, in the SEC example, they will feel that they have a better shot taking their objection to a regulation, facing it in federal court rather than an administrative proceeding within the agency. So I think this is going to generate a huge amount of cases that the agencies are going to have to deal with and that the federal courts are going to have to deal with. A particular source of impact will be the federal courts in DC because they get a lot of the regulatory appeals and litigation. And so I think the federal district judges and the federal appeals court in DC will find themselves with a quite substantial new workload. And just as an aside, they're already hugely overwhelmed by January 6th
Hmm.
criminal prosecutions. And so this is really going to make life difficult, I think, for federal judges in DC. I'm not asking you to sympathize with them. They have a reasonably good life, but it is going to be tough. What impact it's going to have on Congress and on legislation, I think, is very unclear. I
Hmm.
mean, in theory, the answer to doing away with the Chevron doctrine and various other things the Supreme Court has said is that Congress ought to legislate in more detail, more carefully, more precisely, and leave less to the discretion of the agencies. Um, yeah, I mean, I don't want to insult anybody who works on the Hill. And if you're all Democrats, you wouldn't be the ones I'm trying to insult anyway. Um, but do you want Marjorie Taylor Greene filling in the details of the Clean Water Act? Do you want Lauren Boebert determining the interstices of some labor statute? I mean, frankly, if you'll allow me to be blunt, these people are morons.
Uh, um,
Not only should they not be filling in more details, they shouldn't be qualified to vote
I
on
don't
this
think you'll find any
legislation at all.
disagreements here from our loud and Dems.
So, I mean, it's not to say that there aren't smart, capable people in Congress on both sides of the aisle who may take this seriously and say, okay, we need to do more with the nature of the legislation we're passing. And that's fine. I will credit that they may be able to do that in some instances, but then pass that through the filter of partisan gridlock. Um,
Yeah.
and so even if the intelligence and expertise is there, are they going to be able to agree on anything?
Yeah, I think it's they're making this decision at a time when Congress really has trouble getting any legislation passed, and it's really difficult to reach consensus. So it seems like we're getting rid of a lot of the ability to um, have meaningful regulations, and at a time when it's really difficult to um, pass legislation that would support that when the agencies would not have the capacity to do so.
I mean, I would think climate change will suffer,
Yeah.
or the ability to deal with climate change will suffer. Um, and you can go on down the list of uh, regulatory policies that have gotten but can use more attention.
Yeah, absolutely. Um, okay, well, I do want to move on to our next topic, and that is gun safety. It was kind of a mixed bag this term. There was one decision concerning the Second Amendment rights of domestic abusers. That was United States versus Rahimi. That was a 8-1 decision, and the court decided um, that a restraining order on domestic violence abusers that would prohibit them from having a gun does not violate the Second Amendment. And then there was the Garland versus Cargill decision that um, regarding bump stocks.
Right.
And that was another, I believe that was a 6-3
6-3. Yeah.
Yeah, 6-3, and that was conservative liberal.
So you're right. That was a mixed bag. Although what we're really talking about here is the court's still trying to figure out not just the Supreme Court, but the lower federal courts and the state legislatures trying to figure out what the court meant in 2022 in the New York versus Bruin case. That was the case in which the court struck down New York's concealed carry law. New York essentially had placed the burden on the gun owner to justify why they needed a permit to be able to carry a gun outside of the home. And the Supreme Court said that was not consistent with historical practice, that you had to measure in order to evaluate the Second Amendment as to any gun law, you had to measure historical custom and practice, seemingly really at the time of the founding. And that has left courts, legislators, even Supreme Court justices scratching their heads. So what I think is significant about Rahimi, there's two things. I mean, depending on how you view the Supreme Court, if you view the Supreme Court in sort of more societal terms and less judicial philosophy terms, many people commented that there's just no way the Supreme Court was going to unleash domestic abusers to be able to carry guns. Right? It just would make no sense. It would be totally illogical. It would bring the wrath of even a larger swath of society than the abortion decision down on the court. And so from a kind of political standpoint, I think many people believe the court was not going to do that. I think there's broader legal significance to Rahimi. And that is that it showed that the court was not entirely comfortable with Clarence Thomas's 2022 opinion in the New York case. I mean, Thomas, threw out this kind of broad idea that if we didn't ban a particular kind of weapon in a particular kind of situation in 1789 or 1791 when the Bill of Rights was ratified, then we can't do it now. And, what does that mean? I mean, we have a gazillion weapons on the face of the earth that didn't exist in 1791. Are we are we comparing bazookas to swords to try to determine what the law should be? Are we comparing fighter jets, to Trojan horses? How do we do it? And so I think in Rahimi, the court actually showed a little bit of frustration with Thomas's Bruin decision. Now, that's sort of a one-off, right? Will that remain the way the court views how we interpret the Second Amendment? Or was this a convenient and necessary place to say, well, we can't take history totally literally. We have to have some flexibility and some context, and we have to kind of look at how domestic violence was treated. And we can't just go back to 1791 because, with apologies to women on the Zoom, in 1791, women were pretty much the property of their spouses, and they could beat the crap out of them all they wanted, and it wasn't illegal. It wasn't, it wasn't subject of retribution for the husbands. So we don't live in that world, and so the court seemed to show some frustration or uncertainty, at least, with how to apply Thomas's history test. But what does that mean going forward? We're going to have a dozen more cases. There's already a split in the federal appeals courts about a similar federal statute that makes it illegal for a felon, a convicted felon, to possess a firearm.
Mhm.
And some federal appeals courts have said that violates the Second Amendment because it wasn't consistent with our history, and other federal appeals courts have upheld that. So I think that's got to end up at the Supreme Court sometime soon. The federal appeals court in San Francisco that covers California and other Western states said that you couldn't apply that rule, the felons can't have weapons, to felons who were convicted of nonviolent felonies. So that's another wrinkle that I think may end up at the Supreme Court. Minnesota is one of several states that doesn't allow possession or purchase or possession of weapons by 18 to 20-year-olds. The Court of Appeals that covers Minnesota, the Eighth Circuit, declared that unconstitutional in violation of the Second Amendment. So, I think the court has created its own can of worms. And until we have a few more go-arounds of what do you mean by history and tradition and past societal practice, the court's going to need to take more of these cases and help us try to sort it out. And I don't think they're all going to have a happy ending like the domestic violence case did. The bump stocks case was really not a Second Amendment case. It was more interpretation of the statute. The Congress going back to I think it was the 1920s, 1930s, made it illegal for individuals to possess machine guns. And actually it was the Trump administration that first implemented this rule, and then picked up by the Biden administration that basically said these bump stocks, which is a device you add to a gun that essentially enables that weapon to fire almost like an automatic weapon. It can rapid fire, you can take a weapon, it's a single shot weapon, and put a bump stock on it, and it's then capable of rapid firing. But Clarence Thomas, interpreting the statute for the majority, said basically, he went through incredibly elaborate description of how a gun fires and what a bump stock does, and there are even diagrams. If you haven't had a chance to take a look, this is one that I would pull up and actually take a look, because it's kind of remarkable that he has several pages of diagrams of how a bump stock works. But his bottom line is the individual operating the weapon still has to do something in between each bullet. It may only be a fraction. It speeds up the process exceedingly fast, but it still requires some intervention by the individual rather than a machine gun, which goes totally automatically. And so he said that the regulation trying to make bump stocks covered by the machine gun rule didn't work. Now, the court already has one more gun case already for next term. It's got what are called ghost guns. Guns that can be, most common example of a ghost gun is these guns that can now be manufactured entirely on a 3D printer. And they're ghost guns because they have no serial numbers. They're not registered with anybody. There's no manufacturer's record. of these guns. And here too, it's not so much a Second Amendment case as an interpretation of the statute. Are these guns literally guns within the meaning of the federal gun control laws, or are they something else? Do they have to have registration numbers and be recorded by manufacturers, or are they literally a different physical entity that is not covered by the gun control laws? And that the court is already going to decide next term.
Would you say that Cargill is in line with this theme of dismantling the administrative state because it's the court reversing an action by a federal agency, even in this case, one at the time was controlled by the Trump administration?
Yeah, it's striking down a federal regulation. It's kind of a mix of kind of anti-federal regulation, but also Clarence Thomas's brand of what he would call textualism, right? And in his mind, he's literally reading the statute and saying a machine gun is a machine gun, a bump stock is a bump stock. They're not the same thing. The fact that the two different administrations of two different political views had adopted this rule and didn't have a problem with it is irrelevant to Thomas because he's the only one who understands how to read the statute.
Right. Okay, on to our next topic. Oh, and by the way, I do see a few questions coming in on the chat and the Q&A. We'll get to those after this discussion. So the next
I'll
topic,
try to speed up my answers so we have more time. Sorry.
it's okay. Yeah. Reproductive rights. I think following the Dobbs decision, this court was trying to act with a little bit more restraint. Let's see, there was FDA versus the Alliance for Hippocratic Medicine.
Right.
And yeah, so that was a
that's the mifepristone.
mifepristone. Yeah, and that's a 9-0 ruling. And then there was the Moyle versus United States, and that was regarding emergency abortion care. That one was dismissed.
Right.
So
on the FDA, on the mifepristone case, the court never should have taken the case. There's another case that's a First Amendment case that we don't need to go into. But the theme that I want to touch on is what's increasingly happening in our court system, in the federal courts, is people bringing lawsuits because they don't like a policy. And there's a pretty hard and fast, or at least supposed to be hard and fast rule in the federal courts that you have to be an actual injured party in order to be able to bring a lawsuit in federal court. Not just that you're unhappy with the government policy, but that it actually harms you in some direct, tangible, measurable way. And that was an issue here. The organization that challenged the availability of mifepristone is called the Alliance for Hippocratic Medicine. The Alliance for Hippocratic Medicine is a made-up organization consisting of a bunch of doctors and various other people in Texas who are anti-abortion. And I mean, the organization didn't exist before this lawsuit. It basically was made up for this lawsuit. The doctors say if people are allowed to take mifepristone and have medical abortions, they may have complications, and we're doctors who work at hospitals and we're opposed to abortion, but we may find ourselves having to treat these people in the emergency room at our hospitals, and that violates our conscience and our freedom. And this is relevant to the second case too. At the oral argument, the federal government defending the availability of mifepristone said absolutely unambiguously, doctors have a freedom of conscience. Federal law, no federal law requires a doctor who is anti-abortion to perform an abortion against their own conscience. The hospital may have an obligation, but the individual doctors don't. So where's the injury? Right? You're strongly anti-abortion. You don't want to have to be forced to perform emergency services on people who have complications from mifepristone, which, by the way, doesn't happen very often to begin with. And the federal government says to the justices, well, you don't have to do that. And so the court rightly, I think, says there's no standing. Standing is the concept of you being an injured party. And the court says there's no injured party here. They have no interest that justifies their bringing this lawsuit. Now, they may try again. They may try to find some more tangible way to assert a real injury and bring a lawsuit all over again. There was some threat of that after the court decided the case. The other case, Moyle, relates directly to this idea. Idaho has a virtually total ban on abortions. There's actually even a debate about whether you can perform an abortion to save the life of the woman. There's a federal statute called EMTALA. I don't remember, the Emergency Medical Treatment and something and Leave Act. That may not be right, but it's close. EMTALA says any hospital anywhere in the United States that receives federal funds, which is most hospitals in the United States, has an obligation to treat people who come into the emergency room. Its original purpose was to keep hospitals from turning away people who didn't have insurance or couldn't afford to pay, but needed emergency medical treatment and showed up at the emergency room. There was a practice in many places in the country of, literally shipping those people off to some other emergency room because we don't want to have to pay for them at our own expense. But it turned into an abortion issue because the question in Idaho then became, if you show up in an emergency room needing an abortion or needing to complete a miscarriage or something like that, does the hospital have to perform those services under EMTALA? And do individual doctors have to perform those services? There never was a trial. The lower court blocked Idaho's law. The Court of Appeals, I think, if I'm remembering right, upheld the block on Idaho's law. The state of Idaho came to the Supreme Court on an emergency basis and said, we think our law should be allowed to go into effect. It's perfectly constitutional. But while it's being litigated, while there's a trial and all that, would you issue an emergency order allowing the law to go into effect? And the Supreme Court did. It said Idaho could enforce its law. And at the same moment, instead of letting everything happen in the lower courts, the Supreme Court said, we'll allow your law to go into effect, but we're going to treat your emergency application as a request for review, and we're going to grant cert and decide your case. And so they scheduled the case for oral argument instead of simply, allowing it to have the emergency order. And then they got through the oral argument and said, well, we don't really know enough about this case. There's no trial, there's no record. We don't know what Idaho's practices are. We don't know whether anybody's being forced to perform abortions against their will. We don't know anything. And so they dismissed the case with what's called a DIG, D-I-G, dismissed as improvidently granted.
Hmm.
But the justices wrote 48 pages of opinions. Some justices saying we shouldn't be dismissing it. We have plenty of knowledge enough to decide the case. And other justices saying we never should have agreed to hear this case in the first place. And this is what's wrong with the liberal justices, Kagan, I think in particular, excuse me, said this is what's wrong with our so-called shadow docket, our emergency docket. We shouldn't be just picking cases off the emergency docket and taking them for full-fledged review when they're not fully developed cases. So I don't think we've heard the last of that either, because Idaho now, there should be a trial in the federal court. And I would guess it's quite plausible that that case will end up back in the Supreme Court in a year or two.
Do you think there was any political motivation there? Like, we don't want to touch this issue because we know what an impact that might have um, on voters in the November election, and just how motivated voters became after the Dobbs decision, that they were maybe purposely trying to not provoke people on that issue ahead of the election.
It's certainly possible. I think there's a legitimate point to the criticism of the court agreeing to hear the case in the first place because it was grossly premature, and related to the discussion of the mifepristone case. The answer about, the state is saying the federal law is going to force doctors to perform emergency abortions against their conscience. And the federal government had already answered that question in the mifepristone case and said, no, it's not.
Right.
So, I mean, I'm sure the court is not separating itself from the politics of abortion, but I think this was a legitimate kind of soul-searching moment as well for this whole controversy about the emergency docket, what's called the shadow docket, and are we doing too much with cases that come to us on that docket that are not fully developed, and we don't do our best work when we don't have a full record and so on.
Yeah, I want to touch on a point that you were making earlier about how in the case of FDA versus Alliance for Hippocratic Medicine, that was a manufactured organization for the express purpose of this, of getting to the Supreme Court. Do you think that this is a strategy from conservatives that when it's very difficult to get legislation passed through Congress, that instead you try to effectively legislate through the courts?
I do. I think that's happening increasingly, and it's not just organizations that are trying to do it. I think one of the biggest culprits is state attorneys general. And in fairness, I'll say Democratic attorneys general did this during the Trump administration, but now it's Republican attorneys general who are saying our state is injured by X federal law or X Biden policy. The student loans policy that the court ruled on a year ago was brought by the Attorney General of Missouri, saying that the state of Missouri was injured by Biden's student loan forgiveness policy. Well, the court shouldn't have decided that case either. That's utter nonsense. Um, go to the trouble of finding legitimate injured parties and putting together a legitimate lawsuit with real injured people. And I may not like what happens, but I'll defend your right to bring the lawsuit. But this is, as you suggest, just political manipulation of the court.
Yeah. It seems that standing is very critically important for bringing a legitimate case forward.
Should be anyway.
Should be, yeah. Okay. Now, my penultimate topic here, of course, is a big one. So the Trump immunity decision, and also there was the January 6th Ryder decision, Fisher versus United States.
Right.
I'm kind of putting these two together, but of course the Trump immunity case could easily stand on its own. So I was hoping you could go into that one.
Sure.
And then I guess what constitutes official acts and private conduct.
So the immunity case is a perfect example, like the Chevron case, where the court could have gone any number of ways. It could have done some small steps. It could have taken half measures. And instead, it came out with bazookas blazing, and basically went exceedingly far in the decision. And I think there are hypocrisies in the decision that are mind-boggling to me. So this is I don't like unlike some people. There are many Democrats, many liberals who say the court should have just decided this as a narrow issue about Trump's conduct, and it could have decided it in December, and so on. I don't agree with that. I understand that criticism, but I don't agree with that criticism. I think this is a case of first constitutional order. This is an issue of 235-year dimensions, and the court should have taken the time and really put it into it. And if that meant that Trump was not going to have trials, that may be unfortunate, but I think it really deserved consideration. Now, did it get that consideration? That's a fair question. I think now that when you look at the decision, it does look more like the court was trying to delay for Trump's benefit and rule for Trump's benefit. So what the court did was basically say anything that is an official act, and who decides what's an official act? Well, they didn't really make that clear. But anything that's an official act is seemingly absolutely immune from criminal prosecution when the president leaves office. Then there's a category of kind of putative or presumptive official acts. It may not be certain or 100% clear official acts, but seemingly the way it would play out is that the burden would be on a prosecutor to have to show why the president's conduct was not an official act. And perhaps if the prosecutor could show that, then maybe the burden would shift to the former president to make the counter argument. Now, there are a number of things that are really troublesome about this. What the Supreme Court normally does in a case, as many of you know from past experience, is the Supreme Court issues a new rule, and then it sends that rule back to the lower courts to apply that rule. Right? We've now defined what kind of immunity from prosecution a president is entitled to. So now you, Judge Chutkan, in the district court, and you, federal appeals court, apply that rule to the facts of Trump's case. But what Chief Justice Roberts do instead, he has 10 pages going through all the different parts of the January 6th indictment against Trump and applying the rule, at least presumptively, to the facts of the Trump case. And the first step he outlines is absolutely terrifying, literally terrifying, and flabbergasting. He says that anything the President of the United States says to the Justice Department or the Attorney General is an official act and is covered by absolute immunity from prosecution. So when Trump tried to persuade the Attorney General, the acting Attorney General, to threaten states that their electors were false and shouldn't be seated, and he threatened to fire the acting Attorney General if he didn't agree to do that, that's protected conduct. That essentially means that the Justice Department no longer exercises any independent judgment. We hope we have a president who doesn't operate that way, but certainly if Trump is reelected, he would operate exactly that way. He would tell the Justice Department who to prosecute and when and under what circumstances. And even if that was overtly illegal or raised overt conflicts of interest, if you read Chief Justice Roberts' opinion on that part, those are official acts, and the president is entitled to complete immunity. Roberts then goes through 3 other steps. He says that when the president is communicating with private parties, like Rudy Giuliani and Sidney Powell and so on, those may not be official acts and may be subject to prosecution. I mean, he doesn't name them. He just says private, non-government parties. But then he says when the president, and this is also mind-boggling. He says the president has a responsibility for the integrity, legitimacy, and validity of elections in the United States. And so when the president reaches out to state election officials, that may presumptively be official duty or official action. Now, that entire discussion is a false statement. The president has no responsibility for the integrity or legitimacy or validity of elections in the United States. Zero. Not in the Constitution, not in any federal statute, nothing, zero. So when the president reaches out to Brad Raffensperger in Georgia or to the Republican chair in Arizona and says, give me some votes, give me false electors, that Robert's opinion makes it seem at least plausible that that's the president acting in his official capacity. It doesn't decide that, but it says that there may be a presumption that the president is exercising that official duty to maintain the integrity of elections in the United States. Roberts also says in the earlier discussion, when the president reaches out to discuss with his vice president anything, particularly elections, or certifying the elections, that's presumptively official conduct as well. So I, I want to kind of divide this into 2 points. Whether I agree or disagree with the court's ruling about immunity, I would credit the court for taking the time and care to study the history and do at least a thoughtful job of discussing the issue. But that stops with the first part of Robert's opinion. His application of the rule to the indictments against Trump is outrageous, illegitimate, beyond the court's scope, and totally political, and really indefensible. The one other outrageous thing, I know I'm going on for a long time here, I apologize, but I can't not make this other point. The question of the legitimacy of the appointment of Jack Smith, the special prosecutor, was not argued in the Supreme Court. It was not an issue in the Supreme Court. It was not an issue in Tanya Chutkan's court. It was not an issue in the U.S. Court of Appeals, from which the case went to the Supreme Court. But Clarence Thomas went out of his way to write a 10-page concurring opinion in the immunity case that had nothing to do with immunity. Clarence Thomas wrote a 10-page opinion saying the special prosecutor is not lawfully appointed, and this violates the Constitution. Again, not raised, not briefed, not argued, not an issue in the case. What was Clarence Thomas doing? Writing a draft opinion for Judge Eileen Cannon in Florida, who then a week later, 2 weeks later, dismissed the classified documents case. And what did she cite for authority? Clarence Thomas.
Interesting.
So I did a couple of media interviews after that came out, and I was merciless. I said to a couple of people, well, I think the first thing that ought to happen is that they ought to pay Eileen Cannon's salary to Clarence Thomas for the first 6 months of 2024. So that's the immunity case. The January 6th case is a case of statutory interpretation. The court, by a 6-3 majority, says the statute that was one of the bases for convicting January 6th rioters required actual destruction of papers, evidence, files, records, and not just an attempt to disrupt the proceeding in which the ballots were going to be certified. And so that interpretation of the statute probably throws out about 350 convictions. Now, in most of those cases, the individuals are convicted of other crimes on January 6th as well. And so there are only a small handful who may have their sentences wiped out altogether. But it's going to force we were talking about the DC courts and the workload they're going to get from the Chevron decision. Well, they're going to have to go through these 350 cases and resentence these people. And they still have 500 more January 6th cases that they haven't decided. They haven't had trials in yet. So I'm going to contradict myself from earlier in saying I don't think they deserve your pity. I actually think they do deserve your pity.
What I thought was interesting about the Fisher versus United States, the January 6th writers case, it's not the 6-3 majority that you would have expected, because this is a lot of these were 6-3 conservative liberal, but on this one, Justice Ketanji Brown Jackson
joined the majority.
And
Amy Coney Barrett joined the dissent.
Went with the liberals. So I'm wondering if you had any insight into those respective justices making those decisions.
Well, I think one of the themes of this term was kind of the coming out of Amy Coney Barrett and Ketanji Brown Jackson. They both kind of showed us more of themselves than we had ever seen. I mean, Amy Coney Barrett, I think, exercised some independent judgment in several cases, still extremely conservative. Make no mistake, but thinking for herself, not necessarily in every instance just going up and down the line with the other conservatives. And Jackson, too, was expressing herself a fair amount, writing some separate opinions, and kind of letting us see her views a little bit more independently than we had any reason to know prior to that.
And on to our final topic here, corruption on the court and what can be done about it. There's been a lot of criticism about about corruption on the courts, like Justice Thomas taking bribes essentially from a wealthy businessman, and the justices not recusing themselves on certain cases, particularly the January 6th cases where you've got Alito with his flag, which he blames on his wife, and Justice Thomas's wife also has said some things supportive of January 6ers. So I'm just wondering if you could speak broadly about corruption on the court and what can be done generally about it, particularly what Joe Biden announced on Monday,
Right.
his reforms.
So the simple solution is that Congress should require Thomas and Alito to get divorced in order to remain on the. No, just kidding. I'm afraid nothing can be done about it. If we have a Democratic majority, and filibuster-proof majority in the Senate and a majority in the House, I think maybe you could pass an ethics code that has some enforcement mechanism. But I think at the moment, none of Biden's proposals can go anywhere because they don't have the votes to pass anything. And so I don't know that anything can really be done. AOC in the House has introduced impeachment articles, I guess, against Thomas and Alito, and I don't think that's going to go anywhere for sure. I mean, the term limits idea, the Biden's proposal for 18-year term limit has some appeal in that once it was fully implemented, there would be a justice retiring every 2 years. And so every president would get at least one, maybe two nominations. And the hope would be that would depoliticize the nomination process to some extent. I'm skeptical about that. That to me smacks a little bit of trying to put the genie back in the bottle. The nomination process is so deeply politicized that I don't know if you can, pour water over it and try to put out the fire. I also don't know whether it's constitutional, and there's a deep divide. I think Congress absolutely can pass an ethics code and create an enforcement mechanism if they had the votes. That I'm fine with. Constitutional scholars are divided about the 18-year term limit. The Constitution says justices shall serve during good behavior, which for 235 years has been understood to mean life tenure.
Hmm.
the proponents of the 18-year term limit say two things. First of all, it doesn't say life tenure, and nobody's ever ruled that it meant life tenure. But their larger argument is the justices won't be forced to leave the bench. When you reach 18 years, you become a senior justice, which allows you, if a justice has to recuse in a case, for example, a senior justice could sit in that case. um, they can decide cases on the federal appeals courts and the federal district courts. So you're, in theory, they're saying you're still a sitting Supreme Court justice with the powers of a federal judge, and so you're not giving up life tenure. I just find that argument kind of laughable. Um, um, when you implement this proposal, there are going to be 9 people who decide Supreme Court decisions. And there may be a handful of others who decide federal appeals court decisions, but who have the title of justice, or who decide district court cases and have the title of justice. But there's only 9 people deciding Supreme Court decisions.
Yeah.
And are you still a Supreme Court justice if you're not deciding Supreme Court decisions? And if you're not, then I think it would take a constitutional amendment to do away with the life tenure. And that's the tension that exists there.
Yeah, it was unclear to me whether I know that for the first proposal from Biden regarding presidential immunity, that was a constitutional amendment that he's
Right.
proposing. The term limits.
He's just proposing that Congress enact
Okay,
term.
like legislation.
Yeah.
Okay. And then it would be unclear, you would think, whether Congress has the constitutional authority to create
Well, guess who would decide that question?
the Supreme Court.
Yeah.
And generally speaking,
On the ethics
an
thing,
entity in power does not, typically give it up, though we did just see, Biden
right.
do that. But
On the ethics thing, I just want to make one point for perspective's sake, and I feel very deeply about this. As I said, I wrote the authorized biography of Justice Brennan. For about a decade in the end of the 60s and into the 70s until maybe 1980 or so, Justice Brennan went to Nantucket every summer, and he rented a cottage on the end of a wharf in Nantucket. And there came a time when the landlord wrote to him and said, "I'm sorry, I have to raise the rent. I haven't raised your rent in the whole time you've been coming, and the rent's no longer competitive, and I need to raise your rent." And Justice Brennan wrote back and said, "I'm sorry, I can't afford the higher rent." And he stopped going to Nantucket. He didn't look for a billionaire to buy the goddamn cottage or to pay his rent. He stopped going because he couldn't afford it. And I think, to me, that's all you need to know. Right? To me, that says a million words about the conduct of Clarence Thomas and Samuel Alito.
yeah. Okay, well, I want to get to some questions. I just have a few here, but if you guys on the Zoom have come up with any questions as we've been going along, then feel free to ask them, and I will try to get to them. So the first one is from Gael Pian, who asks, will you discuss how judges can be added to the Supreme Court to balance the right-wing 6?
Sure. The Constitution does not set a number of justices That's always been done by statute. So Congress has the power to increase the size of the court. It can't decrease the size. It can't take a seat away from somebody, right? It can't suddenly say we're only going to be 8 and Ketanji Brown Jackson is out. But it can add seats to the court, and it did that early in the history of the court. It went up to, it was 5, it went up to 6, it went up to 10 at one point. It's been fixed at 9 since 1869. Congress passed the Judiciary Act in 1869 that set the number at 9, and they could pass a new law making it 15, 13, whatever they want to do. But again, you'd have to have the votes to do that, and certainly a Republican-controlled House is not going to vote for that, and you'd have to have a filibuster-proof majority in the Senate as well. I personally, I know there's lots of different views about this. I don't like that idea, because if the Democrats do that now to the Republicans, then the Republicans will do it to the Democrats the next time they're in power, and we'll have a Supreme Court of 100 people 50 years down the road. And look how well the Senate functions.
Yeah. Yeah, like I remember that FDR tried to pack the courts
Right.
in his tenure. Trying to get
1937.
what's that?
1937.
37. Yeah.
And it was roundly criticized.
Yeah, I believe it was to get the New Deal passed.
Right.
Like there were some constitutional questions, and so he tried to expand the court, but I guess he didn't get the support within Congress to achieve that.
Well, two things happened. His proposal was to add a seat to the court for every justice who was 70 years old and didn't retire. And that would have given him, I think, 5 seats. So his legislation was being struck down 5-4. And now, had he succeeded, he would have had a 9-5 majority instead of losing 5-4. But there was huge criticism of it, even by his loyal supporters. But at the same time, the court announced an opinion that showed one of the justices in the 5-4 anti-Roosevelt majority switching sides and upholding a law. And so that kind of broke the logjam of importance for the court pack.
Right. Okay. We have a question from an anonymous attendee. So I think this was back to our conversation about the administrative state. He says, aren't we talking about establishing a rule of corporations? That was Mussolini's goal when he launched his fascist state.
Well, I'm not going to respond to the Mussolini part, but I think that the abolition of the Chevron doctrine gives corporations, all kinds of business interests, a lot more power and influence. It allows them to use their lobbying forces in Congress to try to push Congress in certain directions where the agencies may be less able to offset the pressures on Congress. And so I think we will see a lot more corporate influence, yes.
Okay, I've got one from Michael. Are you expecting Biden's recent criticism of SCOTUS will bring Senator Whitehouse's investigations of SCOTUS corruption to the attention of a broader audience?
That's a very good question. I don't know if everybody's familiar. Sheldon Whitehouse, the senator from Rhode Island, has given a series, I've lost count now, I think he's up to about 40 speeches, and like the first 30 he turned into a book, documenting what he said was a wide range of corrupt practices and ethical violations and so on by Supreme Court justices. I don't know if Biden meant to have that effect. I mean, what White House has done is very impressive and well documented and highly detailed. I'm sure you can find them if you're interested. You don't need to buy the book. I think I'm sure they're all on his Senate page. But my thought was that what Biden is doing is actually helping Kamala Harris by giving her a way to make the Supreme Court a major issue between now and November, not just about abortion or voting rights or affirmative action, but about the legitimacy of the court itself.
All right, I've got one more question that was in the chat. This one was also from Michael. Has anyone argued in any ghost gun law cases yet that having a ghost gun per se is a conspiracy to violate federal gun laws?
I have it's an important question, Michael, and I apologize. I have not studied all the litigation over ghost guns, but I don't think that is the principal argument. I think the argument is that the argument in favor of regulating ghost guns is that the Gun Control Act was intended to regulate guns, and that you shouldn't be able to work around the language or intent of Congress by coming up with some creative way to kind of defeat the record keeping and registration numbers and so on. I think that's probably been the major argument.
Yeah. Okay, well, that was our last question. So I think we will bring this to a close. And I just want to thank you, Professor Steve Wermiel, for joining us here tonight. And I want to thank Chris Tandy, Lisa Savaglio, Shelley Tamras, and Heather Gottlieb for helping us out in getting this event going here. And I want to thank everyone who joined us over the Zoom. And yeah, everyone have a great night and tune in. Oh, I should very quickly, I do just want to make a quick plug for our next talk, which is going to be on August 28th. Save money while saving the planet with the Inflation Reduction Act, and that will be at Russ Library in Leesburg. Again, that's August 28th from 7 till 9. Hope to see you guys there. Okay.
Thank you for having me, and good luck, everybody.
All right, have a great night.
Take care.